A fire has occurred. A black mark is visible on a bathroom bench. It might look like obvious fire damage. But legally, the question is not simply whether a mark exists. The question is, what was the mark, and what did it do to the property? This was the issue in R and Archer, a 2009 decision of the Court of Appeal. After an arson conviction, the appellant challenged whether the evidence proved actual damage and whether the jury had been correctly directed on that element. It was not disputed that Ms. Archer entered the church that evening. She later told police that she had gone inside to use the toilet. At trial, two questions mattered: whether she had started the fire and whether the fire had actually damaged the church property. One officer saw singed toilet paper beneath the sink but did not identify damage to the fixtures or fittings. A scene examiner observed slight blackening. However, she could not confirm that the mark was permanent charring, that the melamine had burnt, or whether the blackening would simply wipe away. Damage is not limited to total destruction or permanent burning. Physical harm may be temporary, and even a slight change may qualify if it affects the property's value or usefulness. But the assessment does not stop there. The nature and degree of the change matter. If it is readily rectifiable and the effect is minimal, it may not be damage. A mark is not assessed in isolation. The same deposit may be insignificant on one surface but damaging on another. The relevant question is its actual effect. What changed? How significant was that change? And what was required to restore the property? That was the evidential problem in Archer. The blackening might have been permanent charring, or it might have been soot or debris that could easily be removed. The evidence did not establish which explanation was correct. Because the marking was slight and its true nature uncertain, reasonable doubt remained about actual damage. The jury direction did not make this distinction clear. It allowed the jury to treat charring or soot as damage. But charring and a removable deposit are not necessarily equivalent. The nature, extent, and effect of the mark still had to be proved. The court concluded that actual damage had not been proved beyond reasonable doubt. The arson conviction was therefore quashed. However, the remaining findings supported attempted arson, and that conviction was substituted. For investigators, the practical lesson is to move beyond the appearance of a mark. Establish what the alteration is, how extensive it is, whether the material itself has changed, whether the effect is readily rectifiable, and whether the fire caused an impairment of use or value. Record the evidence that supports each conclusion. R and Archer reminds us that a visible mark is not automatically legal damage. The assessment is one of fact and degree, supported by evidence of the alteration and its effect. A fire is not enough. The damage must also be proved.